Hello, and welcome to the Education for Justice Global podcast series. Today, we will talk about transnational offences, including those related to terrorism and international criminal law from the perspective of the international legal frameworks on human rights and humanitarian law. Is it the case that these two bodies of international law are converging or undergoing a fusion process? I am Dr. Arturo Laurent, and I am with the Education for Justice initiative of the United Nations Office on Drugs and Crime. I am honored to introduce today's panelist, Professor Roger S. Clark from Rutgers Law School in the US. Professor Clark is an expert on global issues, including international criminal law and international human rights. He served on the United Nations Committee on Crime Prevention and Control and represented Samoa and the Marshall Islands before the International Court of Justice. A New Zealander by birth, he holds the title of Board of Governors Professor, Rutgers University's highest rank. Professor Clark, welcome to the podcast.
Thank you, Dr. Laurent. I'm delighted to be here.
Professor Clark, you have an extensive background on international criminal law, including the establishment of the International Criminal Court. From the adoption of the Rome Statute establishing the ICC, and in view of how the international legal framework on countering terrorism has developed in the last few years, are terrorism-related offenses being considered for inclusion as international crimes, or should they be considered?
Well, international law scholars tend to draw a rough and ready bipartite distinction between international crimes on the one hand and transnational or treaty crimes on the other. International crimes are said to be crimes under international law, containing a deep notion of customary law, like jus cogens or peremptory norms. Transnational or treaty crimes are ones that are made criminal by suppression convention, such as the series of terrorism treaties adopted by the United Nations and some of its specialized agencies. During the negotiations leading to the Rome Statute, the argument was made that terrorism and drug crimes were merely treaty crimes and thus suitable for prosecution at the domestic level only, as the treaties prescribed, whereas real international crimes were suitable for inclusion in the ICC's jurisdiction. I must confess that while I've taught international criminal law for over 30 years, I have never found the distinction very clean or very convincing. To the extent it turns on state practice, surely the practice can always change. The categories are not fixed for eternity. Indeed, two of the main international crimes, genocide, major war crimes, have been codified in treaties that look awfully like some of the transnational ones. And efforts are afoot to give crimes against humanity their own domestic suppression regime. If international crimes can become treaty crimes, why can't the practice go in the other direction? After all, the Vienna Convention on the Law of Treaties contemplates the emergence of new norms of jus cogens. I represented the government of Samoa during the ICC negotiations and talked a lot to representatives of small states supporting Trinidad and Tobago, who saw the inclusion of terrorism within the jurisdiction of the International Criminal Court as more of a policy than a conceptual question. They thought it was entirely appropriate to place terrorism crimes, and drug crimes for that matter, within the ICC jurisdiction. While they were parties to the relevant conventions, they understood that they would not necessarily be able to find the resources to prosecute a major terrorism case. Thus, they would be delighted to have a fallback in the ICC, which they hoped would have the resources. Most of the large powers, however, were happy with the current system of state prosecution, to which they devote considerable resources. resources they were not interested in sharing with an international body. I think the conceptual argument is often a cover for this pragmatic position. Opponents of inclusion in the Rome Statute also argued that terrorism is undefined. Frankly, that was not very convincing either. While there is not in 1998 and is still not a general convention covering all instances of terrorism, there are the sectoral conventions on matters such as hijacking aeroplanes and ships, attacking diplomats, hostage-taking, nuclear terrorism, and terrorist bombing. They all provide perfectly adequate definitions of those particular crimes. A fine example of the art of the possible, which we could have carried forward into the Rome Statute, perhaps leaving space for future editions. My impression was that a numerical majority of the 160 states represented in Rome were favourably disposed to thus including the sectoral terrorism treaties in the statute. But the conference operated by consensus, and there was no consensus then. There were efforts leading up to the 2010 Kampala Review Conference on the court to propose an amendment to the statute to include terrorism offences, but no consensus could be reached then either, and it did not make the agenda for Kampala. The proposal is currently trapped in the limbo. Is often the fate of good ideas on the international scene. I do not foresee it escaping soon.
Thank you very much, Professor Clark. Very interesting insights. As the importance of complying with international human rights standards is continuously emphasized by the international community when it comes to preventing, investigating, prosecuting, and adjudicating criminal offenses, what are your thoughts on the convergence with the obligations on member states on international humanitarian law? In the current scenario of terrorism, are terrorism-related acts offenses to be investigated and prosecuted under criminal laws or to be dealt with under the laws of armed conflict?
Well, first of all, any efforts at preventing and suppressing international and transnational crime must inevitably face the issue of how to balance suppression against the protection of human rights, including privacy rights, integrity of the criminal justice process, freedom of speech, freedom of association, freedom of movement. And in a world which has of late spawned an increasing number of authoritarian regimes, we must be unceasingly vigilant at both the international and the national level to protect those fundamental rights. In this respect, I thought it absolutely correct when the United Nations Security Council created an ombudsperson to review difficulties and injustices with the enforcement of its terrorist financing regime. And I applaud the action of the Human Rights Council in appointing a special rapporteur on the promotion and protection of human rights while countering terrorism. The special rapporteurs have emphasized the protection of human rights defenders and other members of civil society. While, however, the holders of the special rapporteur's office have soldiered on bravely and raised a lot of important issues, they have been part-time, unlike the full-time Security Council ombudsman, and grossly underfunded. The current incumbent is a very distinguished law professor, and I have no idea how she finds time to do so much with so little. This is probably an area where an independent person should be appointed full-time to a term of years within the office of the High Commissioner for Human Rights. A lot of resources are going to counter-terrorism, and we could do with more on the human rights end. Secondly, there is a characterization issue here too that can lead to efforts to deny rights. An awkward question arises, as you suggest, whether to describe or evaluate what we call terrorism in a broad sense by criminal law and thus implicating human rights law, or, and this is the key, if the threshold of violence for an armed conflict, either international or non-international, is reached, whether to treat it under humanitarian law, the law of armed conflict. There is a risk when that happens that persons who are entitled to protection under one or other or both areas of law will fall through the cracks and said to be entitled to neither. This is unacceptable. I must insist, for example, that torture is absolutely forbidden under both human rights law and humanitarian law. If people are not protected by the Geneva Conventions, including Common Article 3, they are protected by the Torture Convention and international customary law.
Both systems, both regimes being complementary with each other. On this, and as you now raise the issue or make reference to the right to privacy, for example, the freedom of association, the freedom of movement, do you think there has been an impact on human rights standards in connection with the investigation, prosecution, and adjudication of transnational and international related offenses as a result of measures adopted to prevent the spread of COVID-19?
Well, terrorism represents a threat to human security. The United Nations Secretary General described COVID, with perhaps a modicum of hyperbole, as the most challenging crisis the world has faced since World War II. I see some similarities in the struggle against both terrorism and against COVID. Both struggles invite us to trade off some of our freedoms, like the ones you mentioned, in pursuit of a greater good. The greater good in this case involves the right to a decent standard of health. There is, however, in respect of COVID as of terrorism, a risk of overreaching, and moreover, that what should be temporary, limited encroachments on our liberties will become permanent, or worse, pretextual excuses for repression. I don't know that we're at the position where the Human Rights Council should create a mechanism such as a special rapporteur on COVID and human rights, but it may come to that.
Interesting idea of a special rapporteur for these specific issues, Professor. And on this, how has the role of international organizations and civil society organizations evolved in connection with the prevention of transnational and terrorism-related offenses?
Well, it's dramatic. First of all, the General Assembly and entities such as the International Civil Aviation Organization and the International Maritime Organization have devoted a large amount of diplomatic and secretariat time to the negotiation of the numerous terrorism suppression treaties that I mentioned, and to encouraging their widespread ratification or accession. The General Assembly has also produced a substantial body of soft law in the area. Moreover, especially since the 9/11/2001 terrorist attacks on the United States, the Security Council has invented itself a role as a lawmaker and has built an executive enforcement power around itself. In its first significant foray into the area, Resolution 1373, it purported to enact as positive law some of the substantive provisions of the Convention on Terrorist Financing, a treaty which at the time was wending its way through the ratification process. I'd always assumed that the Security Council's strong Chapter 7 powers related to actions in the case of particular individualized threats to the peace, breaches of the peace, and acts of aggression, not to generalized rules applying as legislation to all member states. There has to be some question about whether these actions are indeed ultra vires. The Council but the practice discontinued, and despite some rumblings, member states have acquiesced. This legislative process has bred a body named, I think I'll get it right, the Security Council Counter-Terrorism Committee Executive Directorate, devoted to encouraging states to comply. This is a serious, professional group of international public servants who delve deeply into auditing the activities of each of the member states in the area. The Council also makes listings of individuals that can seriously affect their rights. It is important, therefore, that the Council, as I mentioned, has also created the Office of Ombudsman to the ISIL and Al-Qaeda sanctions committees to review requests to be removed from the sanctions list. Underscoring my general point, I noticed a document from the UN Office of Counter-Terrorism, which lists 38 parts of the UN system and related organizations, including the World Customs Organization and Interpol, and 5 more observers, all of whom are involved with the so-called Global Compact that gives effect to the General Assembly's 2006 Global Counter-Terrorism Strategy. Indeed, the United Nations is not alone in its counter-terrorism endeavours. The OAS has done some treaty work, as has the Council of Europe and the European Union. The FATF, the Financial Action Task Force, has its recommendations dealing with terrorist financing. Like the Security Council, it has created solid procedures for enforcing the recommendations, even if on their face those recommendations are only soft law. All in all, this is a remarkable accretion of organizational activity. As to NGOs, I can say that those NGOs who work on victims' issues have always been aware of the significance of victims created by terror and torture and continue to discuss those issues. My impression also is that members of the NGO alliances that follow criminal justice issues in Vienna and New York have become much more attuned to terrorism matters, including in particular the human rights issues. I'm sure that is also true of the NGOs who work Geneva on human rights questions and others who work throughout the UN on youth issues, women's issues, and on peace issues. Many of them must wonder about resource allocation, where so much seems to go to counter-terrorism, including substantial extra budgetary resources. The struggle will no doubt continue across the international system to find a balance between punitive treatment of alleged and actual international and transnational criminals, and the human rights obligations of states and international organizations. NGOs, I am sure, will continue to play a crucial role in that struggle.
Professor Clark, your insights into current issues of criminal law, both at the transnational and international levels, are very much appreciated. Thank you so much for taking the time to be with us today and sharing your thoughts and your experience.
It was a pleasure. Thank you so much for having me.
Let's inspire change together and let's work together to achieve the Sustainable Development Goals. Higher education matters, and the United Nations Office on Drugs and Crime is proudly partnering with hundreds of universities from around the world to advance the SDGs. The Education for Justice initiative is part of the global program for the implementation of the Doha Declaration, funded by the State of Qatar. Tune in for the next episode of the E4J Global Podcast Series that will be published soon on our E4J platform. In order to not miss any of our next podcasts or opportunities for higher education institutions, please register yourself at our Education for Justice platform. Let's inspire change together.